Welcome, everybody. This is AML Voices for May. My name is John Byrne with AML Right Source, and I'll be the host of today's program. Today's program is the broad topic of sanctions. We're going to give you both practical advice, some policy questions and issues, and take your questions. We have a Q&A box, so feel free to put those questions in there, and we will get to those throughout the time of the program. So during today's program, I have two experts with us going to talk about these issues. One is Will Skiza. Will is counsel at Davis Polk. He is in the sanctions space, but spent many years at OFAC, the Office of Foreign Assets Control, and we're really happy to have Will with us today. Joining him is Eva Errico. Eva is our sanctions expert at AML Right Source. She's in our FCA practice, and we really appreciate Eva taking the time today to chat with us. So thanks again, and thanks so much. I want to start this way. We have a whole series of things that are going on. Just this week, the European Union issued a fresh round of sanctions, at least 17 packages of sanctions against Russia. And we'll touch on that toward the end. But sanctions are virtually announced every day in the U.S. from OFAC, the Treasury Department, and obviously overseas as well. But let's I hate the term level set, but let's level set. Let's talk about the premise. Let me go to you, Will. Give us a broad definition of sanctions. We're going to talk to all of you, both of you, about sectoral and secondary sanctions and specially designated nationals, those sorts of things. But give us a sense of what sanctions are, big picture, and then we'll talk about some of the specifics.
Sure. And I will, before I get into this, just do the lawyerly thing. I'm speaking on my own behalf and not on behalf of my firm or any of its clients. And none of this is as a technical matter, legal advice. And having said that, the way I think about sanctions is it's a policy tool that governments use to employ economic pressure to achieve a foreign policy or national security goal. And there are any number of ways you can sort of frame the pressure, whether it's sort of very broad restrictions that apply to an entire country or territory, or sort of more targeted restrictions that apply to particular individuals or entities, or that apply to certain classes of transactions. But at the end of the day, what it is a restriction on trade or financial transactions or other commerce that is being employed to achieve a political end by basically imposing a cost on an actor that we disagree with.
And having done this for a while myself, I know that sanctions have been a tool for many decades in the U.S., but obviously much more utilized in the past 25 years, give or take, obviously since 9/11 in terms of responding to terrorism, but obviously it's also been a tool prior to that. But Will, I think one would argue in the sanctions space, as you say, it's a clear national security tool. I want to talk toward the end of our conversation what you think from your practice, and Eva, what you think from your clients. Is it impactful in terms of the goals? What do your clients think about that? And Will, what do your folks think about it as well? And I know that's an issue that's difficult to pin down. I've read a lot of things pro and con about sanctions, but at the end of the day, it's a tool. It's constantly being used, not just by our country, but as you mentioned, globally as well. Eva, let me go to you. One of the things, there's different categories of sanctions, obviously, and I want to talk a little bit, besides the basic ones that Will headlined, secondary sanctions. That's also an issue that your clients deal with. Give us your take on secondary sanctions, and what are some of the challenges with those?
Well, I think hopefully everybody knows what secondary sanctions are, but our clients, I don't think they are very concerned about it just yet, because the clients' obviously are a little bit, they should be more concerned, because if they are not subject to the U.S. sanctions, and then they want to be on the good side of U.S., or they want to do business with the U.S., that they in fact have to enforce U.S. sanctions. And then they just it all comes down on the client side. It all comes down to onboarding the clients, doing the proper KYC, having a very strong compliance AML BSA sanctions program, because they have to we are talking about beneficial owners, we are talking about who's doing business with who, and then we just have to make sure the financial institutions, now we are talking about larger, smaller institutions, they all have their own ways to deal with this. But you just have to, at all the clients, they just want to make sure that neither the client of the financial institution nor their clients are evading any sanctions, either primary or secondary.
Will, what would you like to add to that? Because obviously that's a thing that I know you dealt with both at OFAC and now.
Yeah, thinking about secondary sanctions in particular, I think the real challenge there is that it's not really a legal framework. It's really a policy framework that, there are legal criteria. The U.S. government will, through, a statute or an executive order, will say, these types of activities, if you do them, you can be sanctioned by the U.S. and will cut you off from the U.S. financial system or correspondent accounts or whatever, depending on the specific nature of the sanctions. But they're not enforced sort of on a strict liability basis by civil servants the way that the primary sanctions prohibitions are. They're basically a framework that the U.S. government can use to decide to put someone on a sanctions list. And that's ultimately a political choice. And it's not just based on purely, did you do what the criteria say you can't do, but it's also, have you done that at a level that we view as being particularly serious? Do we think that putting you on a sanctions list is the right way to solve the problem versus diplomatic outreach or some other course of action? And so, when you're, a non-U.S. financial institution trying to figure out how do I navigate this, the easy answer is I will just look at what the criteria are and not do that. But that may not be a practical answer in the context of your business, in the context of the political environment that you operate. If you're a Chinese bank, that may not be the right answer or a palatable answer, when you're dealing with your local regulator. And so there's sort of a risk assessment aspect to it that is inherently subjective and is somewhat guesswork about, where the policy and politics of it all are heading. And that's where the challenge is, because, I can provide advice on that, but at the same time, these decisions are made, in classified settings on, behind closed doors. Things may leak out to the Wall Street Journal or something like that. But at the end of the day, it's a bit of a black box, and you're sort of making, guesses. Informed guesses based on your experience and your understanding of the actors in the space. But there are limits to your ability to really provide concrete advice because of that policy overlay.
Eva, I'm going to come back to you in a couple of minutes to ask you about when a client asks us to help them set up their OFAC. Let's say they're a new institution, because obviously people should be doing this ongoing, but they come to you and say, we want to set up an OFAC compliance program. What are some of the elements there? So I'm going to come back to you in a couple of minutes to ask you that. But I want to ask you, Will, mainly from your days at OFAC, I can remember, and I've been in this space quite a while myself, but in the early days when bankers were trying to figure out from an AML/sanctions perspective what they needed to do, they were very surprised that working with OFAC was different than working with FinCEN or the bank regulators, in large part because back in those days, if they wanted to get direction or recommendations on how to create a program, and I'm being simplistic here, the answer was simply, if you don't not block something, or if you make a mistake, that's a violation. Now, again, very simple. And since then, I know that OFAC has issued more sort of parameters, and infrastructure, if you will. Talk a bit about where we are today in terms of what OFAC wants to see from compliant financial institutions. I realize OFAC applies to all of us, but just stick to the financial industry.
Sure.
Walk us through that, because it didn't used to be that way, and obviously there's a benefit now that we didn't have before.
Yeah, no, I think that's right, and that was really an initiative that moved forward pretty significantly under the first Trump administration, and I think was something that Sigal Mandelker, who was then the undersecretary, really sort of had a strong interest that OFAC really should be saying more about this, because folks need to understand how OFAC thinks about these things, and need to sort of get that on the front end rather than at the back end through enforcement. And so they published in 2018 what they called a framework for OFAC compliance commitments. It's kind of funny they framed it that way, as sort of this is something that informs our enforcement process, but what it really is a set of best practices for compliance programs. And frankly, it very closely tracks the FFIEC manual for financial institutions. So for banks in particular, I don't think there was anything terribly surprising in it. The sort of five elements, I won't use pillars because that's an AML thing, but the five elements, management commitment, risk assessment, internal controls, testing and audit, and training. And big picture, those all make sense. I think really from my perspective, the two key ones are, risk, which is not to say the other three aren't important, but the ones that really drive everything are, in the first instance, the risk assessment. You need to understand, sort of based on your business, whether you're a bank, a fintech, an exporter, what have you, sort of what you're doing and where, who your customers and counterparties are, and how what you do might intersect with sanctions prohibitions. And fundamentally, knowing that and understanding that and updating it as either the sanctions change or your business changes, that everything flows from that. Because once you understand what the risks are, you can develop your controls around those risks and put them in place so that they're reasonable and tailored and commensurate with those risks. And really the controls, I think, are the second sort of critical piece. And, that is things like, sanction screening is kind of the basic, but then also sort of going beyond that, particularly in this world where we're seeing, intense focus on sanctions evasion, are there ways that you're capturing information available to you that may give you risk signals and incorporating that into controls in a way that you can, detect and prevent that from happening again. So, if you have a client who had been sending a lot of stuff to Russia, pre-2022, and then all of a sudden, 2020, the sanctions happen, that stops, but, they all of a sudden start shipping to this brand new company in Kazakhstan, that's the sort of thing, you're not going to pick that up in sanction screening, but you need to have sort of through your transaction monitoring, through your AML processes, kind of rules that will pick that sort of thing up, and then a communication channel that sort of gets that back to the folks that are sort of dealing with the sanctions risks so that they can act on it.
So Eva, coming back to you, I guess a two-pronged question. One would be the one that I said up front, and that is a newer institution says, we're trying to figure out OFAC compliance, sanctions compliance in general. What are some of your recommendations? And maybe the second would be, RightSource gets called in for advising a company on, we don't know that our program is sufficient. So as an audit, not an audit in a technical sense, but looking at their program to see what are some of the gaps. So talk to us a few things about what you see that works well, what you think maybe some of your clients have improved that resonated with you. So in general, give us some recommendations on a good, strong OFAC or sanctions related compliance program.
Well, I see all kinds. I see very good ones. I see not very good ones. I see mediocre ones. Well, if somebody is starting from scratch, like they are opening a brand new financial institution, my very first recommendation is go get legal counsel, because yeah, I can advise you. I can help you with creating a very strong BSAML program that includes the sanctions part, which actually kind of goes hand in hand. Because you have to have very, very strong KYC policy, CIP policy, and you have to have a very good and strong knowledge of what you are doing, where you are doing it, who you are doing it with. So probably a very, very strong risk assessment is like the basic foundation of everything, because from that point on, you can actually kind of map your so there are the things that you have to do, but where your roadmap is where you are focusing most of your energy and most of your resources on. And I mean, I cannot emphasized enough that a very, very strong KYC, CIP policy and rules and what you are following, and then you have to follow it to the T. It's very, very important. Very, very important. And obviously, you have to, the compliance team has to be very, very knowledgeable about what the bank is doing. Because what I see sometimes that they are working in silos. So the one hand doesn't know what the other hand is doing exactly. So compliance addresses certain aspects, what they must address, but then they don't know there are other aspects that they need to focus on. And then when they get in trouble, then they're like, oh my God, oh my God. So if they have to be the compliance team is really like almost the heart of the financial institution, because they have to know about everything, because you cannot mitigate risks if you don't know what the risks are.
That's true.
I think if just
Go ahead, Will.
an important corollary of that, though, is I think it's also very important that the business understands that what their compliance obligations are, and sort of internalizes that they have really a key role there, because at the end of the day, the compliance folks can't be everywhere and they can't see everything, and you really need to have kind of the culture throughout the organization, so that the folks that are actually on the front line, that are sort of taking in these transactions in the first instance and encountering them in the first instance, know when to spot the issues and know when to escalate them. Because if that isn't happening, there's really no way that the compliance folks can sort of suss out everything.
So with that said, training is very important. It's crucial, really, training.
Right. And that sort of gravitates to an age-old issue, and that's the culture of compliance. They say, Will, the tone at the top. And a question came in, I think is relevant for both of you to take a shot at here, related to what you just said, Will, and what you said, Eva. This is the question. Taking into account today's economic environment, things like downsizing of compliance staff and the upheaval in federal government priorities and staffing, for financial institutions with customers that transact internationally and with sanctioned countries, for example, Venezuela, the question is, can a risk-based sanctions program be viable, or are we still at zero tolerance for errors? First, Will, I'll go to you first, because you were both at OFAC and now you're advising people now, and then ask Eva her thoughts as well.
So I don't think we've ever been in a world where there's zero tolerance for errors, at least from OFAC. And I won't speak to your examiners, because I know there are issues there. But OFAC's expectation is not perfection. OFAC's expectation is reasonable controls, good faith effort, and I think where issues have come up that lead to OFAC enforcement, it's been less so, we had a good program, but we missed something. It's more, we didn't have a program at all. We had a program that was woefully inadequate, or we've made a business decision that we want to do this even though the sanctions forbid it. And so those are going to continue to be issues, even if enforcement is deprioritized in the current administration. I'd say we have no indication that that's the case for OFAC as a civil matter. DOJ may be a different story. It's a 10-year statute of limitations now, so this is not the time to be pulling back. Obviously there are financial constraints, and I think one of the things that we saw after the 2008 financial crisis is there were a lot of enforcement actions 5 to 10 years later, because resources were reallocated, and for reasons that are understandable, but that does create vulnerabilities. And so I don't think it's the case that it means you absolutely can't touch sensitive market sensitive areas, but you need to still do it in a way that sort of takes the sanctions risks into account. And certainly something, with respect to Venezuela in particular, the direction of travel there is not a positive one. We are not in a sort of easy world right now. That could change, because one of the interesting things about the current administration is they're they're a bit more willing to sort of turn on a dime based on the views of the president than other administrations where there might be sort of a longer tailed process. So, it's possible that things could change, but, as of right now, Venezuela is one where it's high risk and probably getting higher risk.
That was certainly an understatement there, Will. That was good. Eva, anything else you want to add about that, both to the question and just in general? You've already said, obviously, it's important to get trained staff and do the risk assessment. But in terms of the notion, zero tolerance versus risk-based, it's sort of a hybrid, right? Nothing is, quote, zero, but you don't want to make any mistakes. So if you have the strong training, you have the commitment from the top, the chances of errors are probably pretty low, right?
Yeah, and then if anybody makes a mistake, I'm not saying it's fine. I mean, you don't want to make the mistake, but if you do, I think my experience with OFAC is understanding of, as long as you show OFAC that you are doing all that you can, you found the problem, or the mistake that you made, you remediated it, and you make all the efforts for in the future not to run into the same issue. They are not the big bad wolf, so I kind of, and I know that a lot of people in financial institutions are terrified of OFAC, that they are going to come down and I don't know what's going to happen. But as long as you do whatever you're supposed to do, as long as you really care about trying to do the right thing, I think everybody's gonna do the right thing. Just do your research, do your work, do whatever it's supposed to be, and then just really care about it.
Will, I'm going to make a very clear assumption that most of the folks on the call today know the basics of OFAC requirements, but maybe for the few that might not, that were interested in high level and sanctions, talk a bit about what OFAC requires, because there's blocking, putting things in accounts. Just walk us through the various things that if something or entity or country is on a list, what are some of the obligations specifically for FIs? I know it applies to
Right.
many of us, but talk a bit about that.
Sure, and so this would take more than an hour if I did this comprehensively, but the sort of the sort of core types of sanctions prohibitions are asset blocking prohibitions, and so those would be the ones that apply to, for example, someone who's on the SDN list. And where those apply, the obligation is to block any property or property interests of the SDN that come into your possession or control if you're a U.S. person. And so, if a bank holds an account for an SDN, they're required to freeze that account. They're required to file a report with OFAC within 10 business days of doing that. There's an annual reporting requirement thereafter for as long as the account remains blocked. If you receive a wire transfer, again, sort of that, includes the SDN's name really in any capacity, the originator, beneficiary, one of the financial institutions, name stuck in the remarks somewhere. Same deal. You would block that wire transfer. You would place it into a blocked account, report it to OFAC, and sort of maintain it as blocked going forward. There are nuances. If you're not a U.S. financial institution, you're not obligated to block these accounts or payments. But if you are asked by an SDN to send a dollar payment to someone else, that will clear through the United States and that will get blocked in the United States. So you should have a process in place to make sure that you're not sending that transaction out, because that will get you in trouble at minimum with your correspondent bank and possibly with OFAC if it doesn't get caught and goes through. There are other prohibitions that are sort of transactional prohibitions. A lot of the country sanctions programs are like this. There are some other sort of more targeted, individualized sanctions that sort of stop short of blocking. And there, the prohibition is basically you can't transact with these people, but you're not required to freeze their funds. And so, in that case, where if you're a bank and you get a wire involving Iran that doesn't involve an SDN, you reject it. You send it back to the originator, and again, you have a reporting obligation. And so that's sort of the general sort of framework. There are any number of sort of specialized kind of tailored prohibitions that are much more complicated than this. And there's obviously, much more complicated fact patterns when you get into sort of, more complicated transactions, trusts, trade finance, things like that, where you really kind of have to work through the documents and the transaction structure and figure out what you're supposed to do. But that's sort of the basic blocking and tackling. The prohibitions as a technical matter are strict liability. It's a violation as a civil matter, even if you didn't know you were doing it. They're not enforced that way. OFAC's enforcement is kind of based on a variety of factors under published guidelines. And again, what they're really looking for are cases where someone knew or should have known that a sanctioned person was involved in a transaction and either deliberately flouted the sanctions or didn't have a process in place that was reasonable to prevent that from happening.
So, Eva, when your clients talk to you about sanctions compliance, let's kick off the non-OFAC area. So, European Union, United Nations, that sort of thing. You've already said the importance of any of this is strong training and resources. What are some of the challenges, if you've seen, if any, with your clients when they're trying to navigate the different types of sanction regimes outside of OFAC?
Well, I haven't encountered any challenges yet. However, I do know that there were financial institutions that they didn't think. They said, if we do OFAC, we're good. OFAC covers everything. And then we pointed out, well, that's not exactly, because your risk assessment says otherwise. So we pointed out, and then we helped them move to the right direction. Because, again, your risk assessment is your Bible as your financial institution. You know where you're transacting, you know what you're doing. And if, like, you have to consider not just OFAC. I understand you're in the United States, but you are doing international business. So you actually have to consider other sanctions also.
Yeah, Will, we talked before we started to record about the European Union, and I mentioned at the top of this program the 17 new packages of sanctions against Russia. Can you describe very well, obviously, what OFAC requires. It's my understanding, high level, that the European sanctions also include things like visa bans and asset freezes. You mentioned that, I think, before as well. And that's part of what's in the package to Russia. So give us a quick snapshot of European Union sanctions. I know by definition, it's the whole group of countries have to agree, or at least the majority, if not all of them.
Right.
So talk about how that process works. And obviously, one of the key issues for sanctions compliance in general is to navigate those that may be not one pitted against one another, but maybe there's not an overlap, there's some complications. So again, a client calls you and says, hey, we're multinational, I'm dealing with OFAC,
Right.
got this, and the European Union's doing X. How do I navigate all of that?
Yeah, so the first thing I do is tell them to get an EU qualified lawyer, either at my firm or elsewhere involved. I am decidedly not that. I pay attention to it enough that I feel okay talking about it for informational purposes, but please excuse me if I don't get it completely right on a technical level, because I'm not in the weeds the way I am with the U.S. sanctions. The basic framework is not dissimilar. The sort of core types of prohibitions are the same. The process in the EU is obviously very different because it is a sort of supranational authority. As I understand it, the current rule, it does actually require unanimity. I think they're working to change that. I think in part due to concerns about particular member states, potentially gumming up the works. Like
Hungary and others, yes.
Yeah. You said it, not me.
I did, yes. No. It's been accurately reported, so yes.
So yeah, that's and because of that, there are some challenges in kind of dealing with the sanctions framework. It's obviously decided at the Commission level what the rules are. The implementation is at the member states. So you have 27 different member states implementing. You have 27 different member states enforcing, all with sort of different kind of internal frameworks for who handles these things. different levels of sophistication and enforcement. And overall, just throughout Europe, they're still kind of new at this. I mean, they've had sanctions in place for a long time, but Russia was really sort of the most serious and concerted real sanctions effort that the EU has ever undertaken. And if I'm being sort of chauvinistic or disrespectful of the EU sanctions apparatus, I apologize, right? But that's my perspective as an American and someone who worked at OFAC for a decade. And so there's growing pains involved in that because they don't have sort of the same mechanisms that OFAC has built up over decades to issue licenses, to communicate with the public, to sort of put out FAQs. And they're building all of that on the fly, in a system where you sort of, have 27 different actors and it's hard to get consensus. And so that poses just implementation challenges because it's just, in the US, if you have an issue, kind of who to talk to. It's OFAC. If you have an issue in the EU, you may be talking to the Commission, you may be talking to regulators in one or more member states, and it's a lot more challenging to navigate that from a practical matter. In terms of sort of how you navigate kind of the confluence of US and EU sanctions, I think we've been so far it's been fortunate in some sense that there's been sort of very broad at least policy alignment between the US, EU, and UK on these sanctions, and so that's helped a lot. It's not a world where different jurisdictions are operating at cross purposes, but there are sort of nuances that can create challenges. The EU and UK designated a lot more of the Russian oligarchs than the United States did, in part because the US, I think OFAC rightly had some concerns about the impact of its 50% rule, which says that any entity that's owned by an SDN is treated as an SDN, even if it's not on the list. And these oligarchs have very far-flung economic holdings, and putting one of them on the list can have a ton of downstream consequences that create a lot of compliance headaches for the industry and don't necessarily sort of have a corresponding sanctions benefit. And so the US, I think, was a bit held off a bit on some of the key oligarchs. Dealt with them through some other channels, sort of non-public channels, and then the EU just put them on the list. And so that's been a challenge because there are times where someone may not be blocked as a matter of U.S. law, but if you have a touch point to the EU, you need to worry about that. If you have a credit agreement that sort of brings in EU sanctions in the definitions and in the reps and warranties. You may have an issue, even though as a U.S. company you're allowed to continue to deal with this company that's owned several layers removed by Roman Abramovich or something like that. Mm-hmm. And so those sort of things can be challenging to work through at a technical level and require sort of expertise across jurisdictions and sometimes coordinated outreach to the government. Going forward, I think there's a real question as to is there going to be a fairly significant divergence in the Russia sanctions between the EU and the US? And what does that mean? Because I think we historically, again, sort of pre-Russia, EU sanctions were pretty straightforward. They were list-based sanctions, and you had to comply with them. But there, I think, was a perception that there wasn't a huge enforcement risk. Now there's sort of a real EU sanctions program with respect to Russia that has teeth, and I think you have to take seriously if you're an EU actor. And if the sort of corresponding US sanctions go away, it's going to be very challenging for US companies that have EU presence or vice versa to navigate that, particularly if you have the administration pushing deals with Russia.
Yeah, and Eve, I guess in terms of your clients, just staying current, staying on top of changes that, as Will points out, can turn very quickly is very important as well. I mean, in general, that's important for all of our clients to understand what's going on from a legislative and a regulatory standpoint, policy changes. But in this space, because there's so many announcements on sanctions, particularly from the Treasury, if changes or things get pulled back, our clients have to navigate, as Will said, both what the EU is doing and what the US is doing, especially if there's some divergency there. So that's it. And maybe they don't come to us for that advice, but that's certainly a high level recommendation to make to them, right?
Yeah, absolutely. It is not easy. It's very complex.
Right. We got a bunch of questions here. I'm going to go through some of these. Feel free to jump in, both of you. One is, this is an interesting one, and maybe Will has a viewpoint given that it's about OFAC. The question is, my OFAC program was examined by OFAC. What kicked that review off? There was no deficiency noted by my regulator. Was it the number of emails to OFAC? Was it that we regularly process transactions with one or more sanctions countries? Well, that could be. Result was no action, or was it random selection? What's your experience, both of you, in terms of OFAC examining any of your clients?
So that that seems unusual to me. I have seen instances where OFAC has reached out to clients of ours through administrative subpoena and asked generally for information about their sanctions compliance program, and they've responded to those inquiries and generally resolved with a no action letter. I have not seen anything resembling an actual examination done by OFAC. That seems very unusual to me. And if you're talking, I mean, and maybe that that's just how you were describing the sort of subpoena that I was referring to. If it was something more than that, that's very strange. The only context where I'm aware that OFAC ever did something similar to that is that they used to have sort of a program for Cuba travel providers and remittance forwarders where they would actually do those sort of on-site audits, but that's been gone for years. So that seems very unusual to me. As a general matter, OFAC doesn't have the ability to take enforcement action with respect to program violations the way that FinCEN or a bank regulator would. So they do, as I said, they do like to talk to the industry and do sometimes ask questions, general questions about sanctions compliance programs, but it's sort of more in a information gathering and outreach. One thing we have seen, I guess, which I will mention, and maybe this is sort of relevant to the experience of the questioner, is we've seen a couple times OFAC do sort of industry sweeps of, for example, crypto companies. And there was one of these many years, I guess 6 or 7 years ago, that I had a couple of clients involved in, and that was a mix of we sort of see there's this new industry that we know they're registering as MSBs, they have sanctions compliance obligations. We just want to understand more about what they're doing. Sometimes the hook is we've seen you're operating in this space, you're registered as an MSB, you haven't filed a blocking or reject report in 5 years. Tell us why. And so that's a question you sometimes see. But that sort of thing is more them trying to understand the industry as opposed to hunting for violations. Now, sometimes they come up, sometimes violations come to light through that process, and it could turn into an enforcement action. But I don't think that that's what they're not doing this to try and sort of make cases. They're trying to do this to better understand the industry.
Eva, have any of your clients had that?
I have never heard of that kind of scenario. The regulators, when they go visit institutions, their report, whatever they want to see, whatever they are asking, includes sanctions. But I have never seen OFAC actually just doing sanctions.
I want to thank one of our audience members, Bastian, who has posted the EU Sanctions Help Desk. It's a platform that supports European operators in complying with the EU restrictive measures. It's aimed at I'm reading from this, aimed primarily at small and medium-sized enterprises. It's free of charge. So, Bastian, thank you. We will post this and make sure everybody can get access. But thank you so much for doing that. We appreciate you taking the time. Anything that helps the audience, helps all of us better understand all these different challenges, very useful here. Another question that came, well, I'll save this one for toward the end because this is more of a broader question on the effectiveness. This question is, as AI continues to evolve, has it become a fundamental part of OFAC's operations and reg framework in the fight against financial crime? And to what extent do we trust its accuracy over human expert intervention? You could ask that of any agency, I guess. Will and Eva, any knowledge of what, if anything, OFAC's using regarding artificial intelligence?
I do not know anything about that.
I have not heard anything about that as well. My experience is that they are rarely on the cutting edge of technology. I do think that, and again, without commentary on the overall effort, I do think that, one of the things that the sort of Doge stuff that's ongoing may actually help with is sort of, the process for adopting new technology within government is very cumbersome. And that is an area where if you have to do it the right way because there are all sorts of security and privacy and other issues. But that may be a pathway to doing things a little more quickly. I am aware that OFAC sort of is interested in learning about how the industry is thinking about AI in terms of augmenting compliance, programs. And so I think I think they're probably more in listening mode at this point than having any sort of defined views.
With all the conversations and policy changes on trade and tariffs and that sort of thing, and going back to my point about what the EU is doing regarding Russia, in one of the articles that I read that talked about it, one of the experts said the key is energy, energy, energy. He said, so obviously, oil is a big issue. And I know the Department of Commerce has their export control regulations. I mean, all of this is sort of under the same broad umbrella, but just in general, what challenges, besides the financial and economic challenge, what challenges do the trade and tariff related policy debates and issue have in terms of sanctions? We have evasion, obviously, and sanctions evasion is going to be a priority of this Justice Department, from what I've read, is one of their listed priorities, which relates to this space. But what else from your experience is related to all this? And I realize things are changing on a daily basis, but just at this point in time.
Yeah, so, tariffs, it's interesting because I think, there are times where it seems like the current administration thinks of tariffs as though they were a form of sanction, that they're, an element of coercion. They don't work quite the same way because it's not, they impose costs, but it's a very blunt instrument. You're not sort of, if I'm mad that a Chinese company is buying Venezuelan oil, putting tariffs on Chinese imports of Chinese goods into the United States, it's hard to see how that sort of directly pressures the Chinese oil purchaser. It may pressure the Chinese government to tell the Chinese oil purchaser to stop doing that. But it's sort of, a much blunter instrument than putting that Chinese oil purchaser on the SDN list. And the other thing is it doesn't sort of have the same, at least, and I'm not a customs expert by any stretch of the imagination, but it doesn't have sort of the same private sector compliance downstream impact. I mean, obviously, importers need to care about the tariffs. They'll need to make sure they're classifying their goods properly, getting the rules of origin right and things like that, paying the right amount. And there will be people trying to evade that. And, maybe at some point, there's kind of typologies or red flags of that sort of evasion that, would make sense to ask banks to look out for. I think right now there's just not information that would allow a bank to even know where to begin that inquiry. But, you could maybe see that happening down the road if this ever stabilizes and becomes sort of a quasi-permanent part of the ecosystem. But it's really, from the perspective of how I advise clients, what they're concerned about is the policy of it, the economic impact, not so much the day-to-day compliance. Now, I'm sure, I have friends who work in firms that do have sort of customs practices. I'm sure they're getting a lot of calls about, how do we, manage compliance with this, back in the, last year, it really didn't matter if we were, in this HTS category or this HTS category. Now it's, a difference of 100% tariff. You have to pay a lot more attention to that. And, I think importers will have to build compliance programs around that. Again, assuming that this is kind of a quasi-permanent part of the landscape. I guess the other just sort of legal nerd thing I will mention is the legal authority that President Trump is using for a lot of the tariffs is the same legal authority that underpins the sanctions. And there have been a number of legal challenges to his use of the authority in that manner. And I'm very closely watching those just because it may have a spill-on effect for sort of the sanctions part of the equation as well.
Quick question. Would a foreign bank that engaged in a transaction with an SDN through the U.S. need to voluntarily disclose to OFAC? What's OFAC's authority over that?
So yeah, I mean, any transaction that goes through the United States is within OFAC's jurisdiction. So if a foreign bank did that and no license applied, that's a violation. It's a violation by the U.S. correspondent. The foreign bank likely caused the U.S. correspondent to violate the sanctions. You're not required to disclose in all instances, and you would have to sort of look at the facts and circumstances of what happened and make a decision as to whether disclosure is appropriate. There is a decent chance that if the information was there on the face of the transaction, the U.S. correspondent may have seen this and blocked and reported to OFAC. So you may be getting a subpoena down the road, in any event. But it's not, the fact that there was a violation on a strict liability basis doesn't automatically mean that you need to make a disclosure. It's voluntary for a reason, but it's something you would at least want to think about if that circumstance happened.
Another question came in, and this is obviously broader than sanctions, but the question was under the category of gray lists and sanctions. And questioner asked, would FATF ever put U.S. on the gray list for not enforcing FCPA, CTA? Do we ever cross the line with FATF? That's an excellent question. What I would say is we're going through a mutual evaluation right now. The report's due in 2026. I did see a piece from the former executive secretary of FATF, David Lewis, who said that would never happen. The U.S. would never get on the gray list. I'm not so sure myself, given all the changes. I don't know that particular administrations would care if we were on the gray list, but obviously that's something you want. Since the U.S. helped craft FATF way back in the late 80s, I think it would be difficult. But what I would say, the short answer is the evaluation is going on right now. The report will be probably published in either the February, I think it's a February plenary or a June plenary of next year in 2026. It's going to be very interesting to see, given what this administration said regarding the Corporate Transparency Act and how it's not going to apply to domestic entities, which sort of negates the purpose of the act, in my humble opinion. But it'll be interesting to see. I want to ask both of you about non-financial institutions like financial technology firms, MSBs and that sort of thing. In terms of client recommendations, what are the compliance issues, Eva, in those spaces? Have you had experience with financial tech firms that have come to us and said, hey, what they've said with regular banks, we're trying to figure out and improve our compliance program? What are some of the challenges, if any, that you've seen?
Well, yeah, we do have a handful of MSBs come to us. We do have fintechs and non-traditional financial institutions coming to us. I think it's difficult for them to recruit knowledgeable people. Training is a big point for them. What the good news is that they do know about it and they do want to remediate. That's the good news. It's just a little bit challenging from their end, but they are dealing with it, and they know again the tone from the top. What's the good news is that management, they know their challenges and they try to fix it.
Your thoughts, Will, with fintech firms?
Sure. I think where I've seen challenges arise, there's sort of three kind of buckets that I would put in. First is, access to information, and are they building sort of technologies or business models where you don't know as much about parties to transactions as would be the case in a traditional banking model. And this is especially a problem with crypto, but I think more broadly with fintechs is they don't always build in such a way that you have the same visibility on who is transacting, and that obviously has knock-on effects for sanctions compliance, because at the end of the day, what you're trying to do is to catch the people who are sanctioned, identify them, and prevent those transactions. So that's definitely a challenge, and it's important to I don't think OFAC has ever suggested categorically that you can't sort of explore technologies or business models that intake different types of information or different levels of information than you would normally see on a Swift message. There's no categorical bar to that, but they will at least expect you to think through what that means for compliance. Think through, are there other things we can do in terms of, geo blocking, sort of, running closed systems, other things like that mitigate those risks. The other thing, that's often an issue is a lot of these kind of new things are designed with speed in mind. And that's sort of the use case. What they're trying to sell is, we can do what banks do, but faster. Mm-hmm. And which, I mean, is a laudable goal. I think everyone wants faster transactions, but, the question then becomes, what does that mean for sanctions compliance? Because, is there time to actually look at the transactions as they're happening and do something about it if there's an issue? And again, if not, what are we doing to mitigate that? Because, that puts us in a different posture from traditional banking where there is kind of real-time screening and interdiction. And then the third issue is when you have sort of, and I want to say this carefully and gently and with all due love for my fintech clients, you have folks who are sort of getting into the financial services space, but kind of have a technology ethos. And the whole concept of sort of move fast and break things is the cliche. Right. And that doesn't always work in financial services. And just making sure that you're understanding that you're moving into a space that has these sort of regulatory obligations, that is subject to this type of scrutiny. Frankly, you're going to need relationships with banks who, even if you're not directly subject to the same level of regulatory scrutiny, they're going to scrutinize you that way because they're going to get scrutinized that way. And so sort of that navigating that culture clash and getting to a place where, the people who are doing these really cool things on a technology perspective understand that, we also need to think about regulatory compliance when we're building these things. And if they're socialized to think that way, they can come up with really cool and innovative ways to try and address these risks that sort of more traditional folks might not think about. So you have the potential to sort of not just find new risks, but find new ways to solve the risk. But it's a matter of making sure that the folks that are doing the developing are socialized to think that way.
Oh, that's a great point. Speed and efficiency. I'll ask you both. Well, let me do this one first, then I'll ask you another question. Somebody asked, we know over the weekend the Trump administration said they were going to eliminate the sanctions against Syria. So the question came in, when and if Syria does open up, this is the questioner's phrasing, any recommendations for FI compliance programs? And it goes on to say, slowly permit customers to transact, or if it's legal and it's wide open. So Will, when there's an announcement, it's been an announcement. I know there's not been an official document yet. So that's part of the answer, right? But there's been an announcement. What do you recommend your clients do? Wait until there's finality and more specificity? How does that work?
Yeah, so I think it goes in stages somewhat. I think at the moment, all you have is sort of the big picture announcement that we're going to ease sanctions, and no one really knows what that means. So at this point, like it's premature to even start, I think, planning what it would look like. I mean, you could maybe sort of have high level thoughts, are we interested in Syria? Do we know people who we would talk to? What would that look like? But it's too soon to be doing something. Just sort of given the legal framework around the sanctions, it's very unlikely that they're just going to all disappear overnight. It's going to be phased in. There's going to be various, restrictions and limitations. And so I think we're going to be, for, a decent period of time, in a world where, there will be opportunities, but you're going to have to look at everything very carefully to make sure that you're doing it in a compliant way. And that's, not going to go away in the near term. And at some point, it will probably become more of a normal country. But it's again, assuming there's not backsliding, but this is the start of a process, and it's going to be a process. The other thing that's just worth thinking about is there are risks other than sanctions in dealing in a lot of countries. And, particularly when you have a country that's been sort of, not integrated into the world economic and financial system, there's going to be corruption issues. There's going to be just sort of practical issues of finding, trusted partners, people who can actually have the capacity to engage with sort of Western businesses on the same level. And that's going to take time too. I mean, I think, one of the things I worked on when I was at OFAC was the sort of Obama administration attempt to ease Cuba sanctions. And, there were still, the sanctions were still there, but there was an effort to sort of, open things up a little bit. And one of the things we found is that it was very challenging, even in cases where the sanctions prohibitions were clearly not applicable, for U.S. companies to navigate that, just because the Cubans weren't sort of kind of conversant with how to do business with the U.S. And so there's going to be a lot of that too that folks are going to have to navigate.
In the few minutes we have left, I want to thank both of you so much for doing this. But I want to we'll start with you, Eva, for some overall takeaways and maybe one other point besides the takeaway. Have your clients expressed support, concern in general for whether sanctions are actually effective? Now, I realize I'm not asking you whether you think they are. I'm sure you have your views, but that, do your clients, because in some cases when we are advising clients about money laundering issues or filing SARs, they'll do it, but they'll say, are they looking at this? We're not sure about the feedback. So two-part question, what are some of your takeaways for everybody going forward? And do you hear anything from your conversations on whether they feel the programs are at least in part successful?
I have not heard anything back if it's successful. I know that they are very concerned and very, well, I don't want to use the word scared, but they really, really want to do the right thing. I have not, nobody ever mentioned if it's successful or not successful at all. And my takeaway, really, just make sure that your basics are covered. You are very strong on them. And just one more thing, as far as practical professional in the industry, if it's not documented, it doesn't exist.
Good point.
So people talking and TV, whatever it is, if it's not documented, as far as I'm concerned, it doesn't exist. So I just would like to see the documentation. But a very, very strong compliance, very strong program, it goes a long way.
Will, probably not appropriate to ask you whether you think they're effective. You spent all your career working for OFAC and now with clients. You can, of course, or at least what your clients say. But what are some of your takeaways?
Yeah, so I was just a lawyer there, so I wasn't in charge of making them effective. I was just, I actually probably made them slightly less effective by making sure they were legal. So, I will say, one thing that I've noticed sort of doing this on the private sector side is a lot of the, at least for my clients, a lot of their compliance resources and attention and the stuff that they bring to me deals with things that are very complicated, but really don't go to the heart of what the sanctions are meant to achieve. I mean, we have so many issues related to securities, like secondary market securities transactions involving Russian securities or derivatives tied to Russian securities. And almost none of these have any, impact on what Russia is actually doing. And we just spend hours sort of digging through the consequences of various sanctions prohibitions for those. And I think, the securities industry in particular is one area where I think OFAC doesn't entirely understand what it's doing when it imposes sanctions that impact it, and would benefit from sort of listening to industry a bit more and trying to tailor some of its rules to address those scenarios. In terms of sort of big picture takeaways, I would say we're obviously we're at the beginning of a new administration. What they're planning to do is still taking shape, and it's very hard to say where things will go. But I think it is clear that sanctions remain sort of part of the policy toolkit. It's something that will be used, and I think it would be a mistake to sort of read tea leaves based on sort of perceptions of overall pullback from corporate criminal enforcement and extrapolate that to this area, because there is a civil element to it where the DOJ doesn't run how OFAC enforces things. There's a national security overlay, and I think a lot of what they've been saying sort of very clearly kind of carves out national security as something that's not affected by these sort of pullbacks of enforcement or regulatory scrutiny. And then the other thing, again, and I mentioned this before, is sanctions. The statute of limitations was extended to 10 years. And so, this administration is not the last word on things. And so, what you're doing now is something that could be looked at, 5-10 years down the road. And so you want to be in a position to, explain what you were doing, before an audience that may be very different than the one that's there now.
To that point, we did a recent webinar we did on corruption. Former DOJ attorney said the same thing, that the FCPA, which has been paused under this administration, is a 5-year statute of limitations. So institutions should not feel that it is an opportunity not to have strong anti-bribery and anti-corruption processes and procedures. So, Will, I think that makes a ton of sense. Eva, Erico, Will Skiza, thank you so much for taking the time today. Our webinar next month will be on risk assessments. You're going to receive a recap email from today's session and information on how to sign up for June's session. Thanks, everybody. Thank you for the questions. We got to most of them. We didn't get to all, but really appreciate the participation. Thank you so much. And for those of you in the U.S., have a enjoyable Memorial Day weekend. To all our other audience members, have a enjoyable, safe weekend yourselves. Take care, everybody. We'll talk to you next time.